appeal in the matter of Kajima Construction Europe Ltd and another Childrens Ark Partnerships Ltd.
Yes, Mr. Holroyde.
My Lords, good morning. I appear together with my learned junior, Mr. Samar Kazmi, for the appellants, who are the defendants in the proceedings, and then friend Mr. William Webb, soon to be King's Counsel, because alas, not yet.
Not yet, no.
He is on behalf of the respondent, who is the claimant in the proceedings.
Yes.
My Lords, the approach which I will adopt to my submissions it will be to place them in 5 parts. First of all, a very brief look at the landscape and the boundaries of the appeal. Secondly, the law. Thirdly, my submissions on appeal. And fourthly, the position of the guarantor, the second defendant. I said 5, there are in fact 4 parts. My Lord, so far as the landscape is concerned, it's common ground in this case, as it was in open, which is an authority we'll look at in due course, that a clause requiring parties to follow a specified dispute resolution process can in principle create a condition precedent to the right to commence court proceedings. Secondly, there has been a determination in this case that, assuming enforceable, there was a condition precedent of that kind. And from that determination of the judge below, there is no cross appeal. The court below also determined that it had power in the present circumstances, subject to the exercise of its discretion, to set aside the claim form under CPR Rule 11. And again, there is no cross appeal from that decision. Finally, so far as discretion is concerned, the respondent relies on the judge's reasons below for the exercise of her discretion and brings no respondent's notice with further or other reasons. Accordingly then, if this court agrees with us that the ADR provisions are enforceable, and if this court agrees with us that the learned judge failed to take into account matters relevant to the exercise of her discretion and took into account irrelevant matters, then we will invite the court to exercise the discretion afresh and on our submissions to set aside the claim form. My Lords, there is then a discrete debate about the position of the second defendant, the guarantor. My Lords, that is the landscape. Can I now look at the documents, the contracts and the other documents? And we will largely be in the supplemental bundle. And I can take this quickly. We may have to occasionally go into the core bundle. The first document to look at is, of course, the project agreement, which sits at the top of the string of contracts. Your Lordships will find that behind divider 1 of the supplemental bundle. Your Lordships will see that it was entered into on the 10th of June 2004. Your Lordships turn please to page 10. You will see that in clause 3, the agreement commences on the date of execution, 10th of June 2004, and Project Co's rights and obligations to carry out project operations shall terminate automatically on the expiry of the project term. My Lord, the expiry of the project term is the 9th of June 2034. So this was a relational contract for 30 years, and it has 11 years left to run.
Sorry, 19th June 34.
9th of June 2034.
9th of June 34.
My Lords, page 28. This sets out paragraph 12, clause 12 of the project agreement that runs to more or less 3 pages. I will briefly go through it, but it is the same. Sorry, forgive me, I'm moving on. Yes, can we go through clause 12? So 12.1, the Trust and Project Co shall establish and maintain throughout the project term a joint liaison committee consisting of 3 representatives of the Trust and 3 representatives of Project Co, which shall have the functions described below. 12.2, describes that the functions of the liaison committee shall be, and then there are three functions. We're concerned with 12.2c, which is that in certain circumstances, pursuant to Schedule 26, to provide a means of resolving disputes or disagreements between the parties amicably. 12.3, the role of the liaison committee is to make recommendations to the parties which they may accept or reject at their complete discretion. Neither the liaison committee itself nor its members acting in that capacity shall have any authority to vary any of the provisions of this agreement or to make any decision which is binding on the parties, save as expressly provided in Schedule 26. My Lords, over the page, if we may, a couple more provisions to look at. 12.5. Subject to the provisions of this agreement, the members of the liaison committee may adopt such procedures and practices for the conduct of the activities of the liaison committee as they consider appropriate from time to time, and A, may invite to any meeting of the liaison committee such other persons as its members may agree, in accordance with clause 12.6. And then, my Lords, just so that you're aware, 12.8, the liaison committee shall meet at least once each quarter, unless otherwise agreed by its members, and from time to time as necessary. Finally, in the project agreement...
Sorry, do we need to note 12.6? That's all.
Oh, yes, of course. Recommendations and other decisions of the liaison committee must have the affirmative vote of all those voting on the matter, which must include not less than one representative of the trust and not less than one representative of Project Co. Now, my Lords, in this bundle behind Divider 3, we're still in the project agreement, and here is Schedule 26, which contains the dispute resolution procedure. We don't need to look at it where it lies within the project agreement, because we'll take a look at it where it lies identically within the construction contract. So, my Lords, behind Divider 4, we have the construction contract. And can I first take your Lordships to page 133 and clause 9.7. This is a familiar clause in these sorts of contracts. Notwithstanding any other provision of this contract or any of the other contractor documents, no claim, action or proceeding should be commenced against the contractor after the expiry of 12 years from the actual completion date. Now, if your Lordships have my skeleton to hand, just so that we can get these dates, we produced in Appendix 2 of the skeleton a chronology. And in the chronology, we set out the date of the works completion date, which sets the clock, the 12-year clock, ticking. So if your Lordships have the chronology, the third entry, 2nd of April 2007, that was the works completion date, or the actual completion date for the purposes of the construction contract. And it therefore follows, and this is the fourth entry, that, sorry, forgive me, 2nd of April 2007, limitation will expire on the 2nd of April 2019. That's the point there in the chronology. So that's 12 years from the actual completion date. So, my Lords, back to the construction contract. Paragraph, this is page 150, clause 56. Except where expressly provided otherwise in this contract, any dispute arising out or in connection with this contract shall be resolved in accordance with the procedures set out in Schedule 26.
I'm sorry, Mr. Hargreaves, excuse me, the page reference again?
My Lord, I'm so sorry, that's page 150.
Thank you very much, sorry. Yeah.
And page 153 is the next. And clause 68.2, please. Subject to the provisions of the dispute resolution procedure, both parties agree that the courts of England and Wales shall have exclusive jurisdiction, and so on. My Lords, then please, behind Divider 5, this is now Schedule 1 to the construction. agreement. And within Schedule 1, page 165, and roughly in the middle of the page, just a little way above the second hole punch, liaison committee means the committee referred to in clause 12 of the project agreement. My lords, we've just looked at clause 12 of the project agreement. Moving on, behind divider 6, we're still within the construction contract, and here we have Schedule 26, which is the dispute resolution procedure.
Sorry, page again?
174, Lord.
Thank you.
So we start at paragraph 1, if we may.
173, the title page, that has been retyped to refer to Childrens Ark and Kajima.
Yes, it must have been.
So that there, at any rate, it's not a simple by reference, as it were, that somebody's gone to the trouble of typing out for the construction contract the right parties.
Yeah, indeed so. Indeed so. My lords, page 174, paragraph 1. The procedure set out in this schedule, dispute resolution procedure, which I may from time to time refer to as the DRP, shall apply to any dispute, claim or difference arising out or related to this contract, except where it's been excluded from this procedure by an express term. And then clause 2 essentially says that this procedure will not impose any preconditions or prevent or delay any party going to court to obtain essentially an injunction or summary judgment. The implication there, of course, being that it may well prevent you going to court for other things. 3, liaison committee. Subject to paragraph 2 and 6 of this schedule, all disputes shall first be referred to the liaison committee for resolution. Any decision of the liaison committee shall be final and binding unless the parties otherwise agree. And 3.2, where a dispute is a construction dispute, the liaison committee will convene and seek to resolve the dispute within 10 business days of the referral of the dispute. My lords, paragraphs 4 and 5 provide for mediation and adjudication respectively. Each of them is optional, and therefore we needn't be detained by them. Clause 6 deals with a fast track procedure, which again did not apply in this case, and again, therefore, we need not look at it.
And is also optional, isn't it? We get a may in 6 point.
Yes, indeed, sir. Thank you. Now, we then come on, of course, to clause 7, court proceedings. All disputes, to the extent not finally resolved pursuant to the procedures set out in the foregoing provisions of the schedule, shall be referred to the High Court of Justice, and so on. So, my lord, I'll have something to say about those provisions, as you expect in due course, but for the moment we're just introducing them. My lord, the guarantee appears...
just before you move on, Mr. Hargreaves,
yes.
In Schedule 26, you took us to clause 3.1.
Yes.
Page 174. In clause 3.2, is construction dispute defined somewhere?
That's a very good question, my lord. I'm quite sure it will be in the project agreement, or possibly in Schedule 1 of the construction contract. We have that.
Well, don't let me take you out of your course, but perhaps at some point you could assist us with that.
My lord, I'll ask my energy to take a look in the meantime. My lords, briefly, the guarantee. I don't propose to read out the relevant parts of the guarantee now. I'll be coming on to that in due course, but just so that you know where it is, it's behind divider 7, and we will be interested in clause 2.1, and my learned friend is interested in clause 2.4. Now, may I ask your lordships now to, again, have the chronology to hand, because we're going to come on to a standstill agreement and variations to it, which I hope to shortcut reasonably effectively. Now, in the chronology, your lordships see from the third line that actual completion date was the 2nd of April 2007. It therefore follows that limitation will expire on the 2nd of April 2019. And so from the fourth line of the chronology, your lordships will see that the parties entered into a standstill agreement 3 days before the expiry of limitation. And it was that knife edge of time that I was referring to in the opening remarks in my skeleton argument about parties playing with fire when they stand on the brink of limitation. Let us look at the standstill agreement. That appears behind divider 8 and is dated, as we've seen in the chronology, the 29th of March 2019. If your lordships would be kind enough to turn to page 193. The definition of effective date towards the top of the page means the date of this agreement. So that's the 29th of March 2019. And beside the lower hole punch, the standstill period has the meaning specified in clause 2.2. My lords, over the page, just a few clauses to look at. Page 194.
Just by way of the background to this, so I'm clear, this is the standstill agreement.
Yes.
We go back to page 192.
Yes.
The factual background, as summarised under A, B, C, and so on, is this right? That this is indirectly a post-Grenfell, as a result of post-Grenfell checks?
Very probably, yes.
I mean,
there's a deal of nodding.
I mean, it's not the first of these I've seen, but
No.
My understanding is in the TCC there are an awful lot of these cases which were triggered quite reasonably as a result of checks carried out.
That's right. Yes.
Yeah.
Yes, this is no exception.
Yeah.
And my client Kajima undertook to carry out the remedial works at its own cost and has done so.
I understand that.
And it was then how the matters unfolded after that.
Yeah.
So yes, so this is the, as you say, my lord, this is the standstill agreement, page 194. The relevant clauses are set out at 2.1 to 2.4. 2.1, in a familiar form, the parties hereby agree that for all purpose of any defence argument based on limitation time bar late fees, and so on, time will be suspended during the standstill period. No party shall raise any limitation defence, nothing in this agreement shall be construed as acknowledgement that there may have been a limitation defence. And then 2.2 explains the standstill period. Standstill period means the period starting on the effective date, which we've just seen, the 29th of March, 2019, and forgive me, the period starting on the effective date will be the period from that date until 30 days after notice given in accordance with clause 11, stating that the standstill period is no longer to apply is given by either party. That's one option, that's the notice option of 30 days. Or 2.3, in any event, the standstill period will terminate automatically 24 months from the effective date unless the parties agree beforehand in writing that they consent to the standstill period being further extended. So there are two ways that the standstill agreement can come to an end. The first is on notice, the second is simply by passage of time. And in the second case, and I'll come on to this point, there's no need for any notice. 2.4 is an important clause. Nothing in this agreement shall prevent, as between Project Co and the building contractor, taking any step in the dispute resolution procedure set out in Schedule 26. And then D, issuing and dispatching and serving proceedings in relation to the dispute between the parties during the standstill period or otherwise. So, in other words, your lordships have the chronology. You've seen that the standstill agreement was entered into at the very brink of limitation. Clearly, the parties saw fit to take that into account in the standstill agreement, and so as to permit one another to comply with the Schedule 26 requirements and even to issue proceedings during the standstill period, no doubt in order to negate the obvious attendant risks of the standstill agreement expiring and then there only being 3 days left of limitation. Well, so my lords, that's the standstill agreement. If your lordships would be kind enough to pick up the chronology, there were several variations. There were 4 variations for the standstill agreement. The first was on the 7th of April, the second was on the 29th of March 2021, the third was on the 28th of June 2021, and my lords, can we perhaps go to the 4th and last extension, 27th of September 2021, that's behind divider 13.
Mr. Holroyde, if you just used the word extension there, am I to understand, are we to understand, that it's common ground that the effect of the standstill agreement was to extend the limitation period to, effectively as a result of the 4th variation, the 29th of December 2021?
Exactly.
Yeah, I mean, I only ask that because sometimes there are arguments about what standstill agreements mean.
Certainly.
But in this case, there's no dispute that the effect of the 4 variations was to extend the limitation period to the 29th of December 2021.
Correct, my lord.
Thank you.
And I'll pick this point up in the drafting, but one has to keep in mind that the key limitation period that we're talking about is a limitation period provided for by clause 9.7.
Yeah.
Not so much the Limitation Act 1980. So here it is then, it's the 27th of September 2021. At page 270, please, we have clause 1. Clause 2, I'm terribly sorry, variation. With effect from the variation date, the parties agree to further amend the standstill agreement as shown in the copy of the standstill agreement attached to Schedule 1 to this agreement, where deletions and underlinings and so on. 2.2, except as set out in clause 2.1, the standstill agreement as varied by the first 3 variation agreements shall continue in full force and effect. My lords, 273 brings us to the Schedule 1 that's referred to, and then if we may turn through, please, to 275. Your lordships will see, just by the second hole punch, the effective date remains the 29th of March 2019. The standstill period over the page is still as it was previously defined. And then at the foot of 276 we have clauses 2.1 and over the page 2.2, 3 and 4 again. So 2.1 remains the same as drafted apart from a bit of tidying up. 2.2 has been changed, so it's to extend the period, it's to reduce the period of notice required for terminating the standstill agreement on notice, and 2.3 extends the backstop, as it were, of the standstill period where it terminates automatically to 33 months, and your lordships can see the course of the variations that were made prior to this point: 24 months, then 30, and now 33. And as your lordship has quite rightly pointed out, that means that limitation expired, or would expire, on the 29th of December 2021, and without need for any notice. Well, my lords, may we now turn to the correspondence, and I can go through this very quickly. The first letter then is behind divider 14, and your lordships can also follow this in the chronology. On the 30th of November, my client solicitors write to the respondent, paragraph 3, say, as between KCE and your client, there is a standstill agreement as varied in respect of the matter set out therein. The standstill will automatically terminate on the 29th of December 2021 unless terminated sooner. Paragraphs 4 and 5 describe the remedial works that KCE has performed. In paragraph 6, KCE asserts, although there was an issue about this, but KCE says it has done those remedial works successfully. A great deal of cost has been incurred, and at paragraph 8, there's been advantage to the respondent also, because now you have brand new cladding on a building that's 14 years old. And so paragraph 9, KCE considers at least that it's done, that it has met all its possible liabilities, and so far as they're concerned, that is end. So in paragraph 10, accordingly, they write, KCE will not be extending the standstill, but instead wishes to document formally and capture a full and final settlement of liability. We understand our clients have been in contact. So there's a clear statement that KCE does not intend to extend the standstill, and there was no need for them to write this letter, but they did so, and that left plenty of time for the respondent to go through the Schedule 26 process and then issue proceedings well within time.
So this isn't a notice?
No.
That with the change period of 10 days?
No.
It's simply bringing to their attention that they won't extend it further, so effectively the automatic date kicks in.
They expressly refer to the automatic termination in paragraph 3.
Yeah.
So it's a clear statement of intent, and it's a clear warning that the standstill period is going to expire.
Yeah.
Lords, the divider 15 is the next letter. This is the reply, page 283. I don't need to read all of the letter. Paragraph 4, Bev and Britain say, as you note, the current standstill agreement will terminate automatically on 29th of December 2021. So there was no doubt in both parties' minds what was about to happen. Paragraph 5, over the page. In the circumstances, in the absence of an extension to the standstill agreement, you will leave our client with no option but to commence proceedings against your client to protect its position. And so on. It's disappointing. At the very end of the letter, please, in order to allow the remedial works and validation process referred to in point 2 above to be completed and for a reasonable period of time for discussions to take place, please confirm that an extension to the standstill to the 31st of March 2022 can be agreed. All over the page, divider 16, 10th of December 2021, page 285. Over the page at 286, please, paragraph 7. We note that absent early discussions and agreement, you advise it will be necessary for your client to commence proceedings. That is understood. Our client will similarly reserve its position as to any failure by your client to undertake the necessary pre-action steps in advance, notwithstanding the time available to it and our client's attempt to resolve any claims on a without prejudice basis through effective remedial works. Now again, my lords, as at this date, the 10th of December, there was still time for the respondent to go through the procedure in Schedule 26 and then issue proceedings in good time. My lord.
When you say, I'm sorry to interrupt, when you say go through the dispute resolution procedure, what does that mean?
Well, what I mean is to refer the dispute to the liaison committee for 10 days to elapse, successfully or otherwise, in terms of resolving it, but if unsuccessful after 10 days, then to issue proceedings.
Thank you.
My lords, divider 17, please. There are 2 points to pick up in this letter, which is dated the 16th of December. Your lordship can see the clock ticking down. Paragraph 5, please, is the first point over the page. This is a point for later on, but may I just ask your lordships to note that paragraph 5 sets out, as known to the respondent, as at the end of 2019, what the trust's position was. And the headline, really, is that the trust's position is that there have been these defects. The defects were reported to the help desk. The defects were such as to breach something known as the safety condition. And then when all is said and done in relation to that, the trust say that means we are entitled to apply deductions to Project Co's monthly payments. And in the final bullet, your lordships will see that a calculation is performed, and the second sentence says, on the basis of the figure set out by the trust, the total number of service failure points will be 14 million. And in the bullet point above, forgive me, which I should have taken you to, the money claim, we calculate the value of the trust claim 24 December 2021 on the basis that they've advanced previously to be 21 million. So I'll come on to this point later, but it's important to realise that the respondent knew perfectly well how the trust was putting its claim and knew perfectly well how it might be calculated in due course. Returning to the narrative, may I ask your lordships to look at paragraph 12. As we've said, if an extension to the current standstill cannot be agreed, then our client will have no option but to commence proceedings against yours to protect his position. Proceedings will be issued on the 23rd of December, and we hope that won't be necessary. My lords, we needn't turn it up, but on the 21st of December, and this is in my chronology, the claim form was issued. Continuing through the chronology, on the 12th of January, my client called for service of the claim form, and then if your lordships turn behind divider 19, on the 18th of January 2022, the respondent was reluctant to serve the claim form, and over the page, on page 292, the respondent said this, second paragraph, it's our client's intention following the meeting on the 26th of January to convene the liaison committee to discuss the matter. Pursuant to clause 12.10, the liaison committee meeting would have to be convened on not less than 10 business days' notice. The liaison committee is a mandatory part of the dispute resolution process. Pursuant to Schedule 26, in usual circumstances, our client would have first engaged the dispute resolution procedure under Schedule 26, and in particular the liaison committee, but due to limitation issues and your client's refusal to extend the standstill, our client was forced into issuing proceedings. However, it's clear the parties should now comply with the dispute resolution procedure. Therefore, it's our proposal that you agree to one of the other courses, agree in writing to extend the deadline to allow the process to run its course, or agree in writing that once the claim form is served, proceedings are stayed. Our client is confident that it's possible to settle the matter through the above process, requiring its claim form to be served and prepared, particularly the claim will be costly and time-consuming and counterproductive. And then there's a suggestion that the stay is for 2 months to allow the parties to resolve the matter through the liaison committee. Now, my lords, this is not in my chronology, and it ought to be. The claim form was served on the 27th of January 2022. There was then further correspondence, but on the 3rd of February 2022, which is in the chronology, Kajima issued the present application, and that can be found behind divider 21. And behind divider 22 is the evidence accompanying the application. Could I just draw your lordship's attention very quickly within the witness statement to paragraphs 24 through to 28. And your lordship needn't read any of this in detail, but this says very much what one might expect it to say in the circumstances. paragraph 25, failure to comply with the requirements of the dispute resolution procedure. The claimant solicitors agree they have to comply with it, paragraph 26. And just under paragraph 26, there is a subparagraph A, quoting from the letter that we just looked at, from the claimant solicitors, and then the assertion beneath it. For the reasons set out above, there was nothing to stop the claimant from referring the matter to the liaison committee before commencing court proceedings. And then various further references to correspondence. 27, In circumstances where the referral for resolution is a condition precedent to the entitlement to commence proceedings, the claimant solicitors accept they haven't complied with that requirement, and C, the claimant commenced and issued court proceedings in breach of the requirement, and they had no right to do so at the time they did it. And then in paragraph 28, the assertion the court therefore does not have jurisdiction, that was abandoned below, or, and this was proceeded with, that the court should not exercise any jurisdiction which it may have. A few hours later, the respondent issued its own application for a stay of the proceedings, and that can be found behind divider 23. The evidence in support of that application is behind divider 24, and again there are just a few paragraphs to look at here. First of all, page 310, the respondent's solicitors assert, paragraph 8, third line. In particular, the claimant is requesting this stay to try and resolve the dispute via without prejudice discussions or contractually agreed ADR mechanism. And then page 312. Paragraph 24, reference to the fact that there had been previous standstills, the remedial works were nearing but had not yet reached completion, and the trust had agreed, but then recording that the defendant by letter of the 30th of November refused a further extension to the standstill agreement. Finally, page 313, paragraph 27, if that does not prove to be possible, the dispute needs to be referred to the liaison committee. The liaison committee is mandatory, and so on and so forth, refers to clause 56. Paragraph 28, all disputes shall be first referred to the liaison committee, and 29, contractual obligation, and then reference to the possibility of mediation after the liaison committee. The obvious reason for going to this correspondence is to point out that at this time at least, there was certainly no suggestion on the part of the respondents that there was anything wrong with the liaison committee procedure, and certainly not that there was anything unenforceable about those obligations to go to the liaison committee. And as if that were not enough, behind divider 26, page 319, the respondent referred the dispute to the liaison committee. You should see that last paragraph, 18th of March 22. Accordingly, pursuant to clause 56 and paragraph 3.1 of the schedule 26, our client hereby refers this matter to the liaison committee for resolution. So, my lord, we can for the moment close the supplemental bundle. And just because it fits here in the chronology, may I briefly take your lordships to the particulars of claim in the core bundle behind divider 8. Now, just to complete the chronology, your lordships will recall that the two applications were issued on the 3rd of March, which is a Thursday. By the Monday, the 7th of February, Mrs. Justice O'Farrell had examined the papers and looked at those applications, and she'd made an order for particulars of claim, further evidence in the applications, and the listing of the strikeout application on the 28th of April 2022. And so in accordance with that order, particulars of claim were served, and those are behind divider 8 in the core bundle.
What was the date of her order?
The date of her order is the 7th of February, and, my lord, it is in the...
So the applications were made on the 3rd of February?
Yes.
And the judge made her order on the 7th of February?
On the Monday following.
Yeah,
having no doubt taken the papers home at the weekend. And so pursuant to
Good
that
to see
order...
the TCC in efficient hands.
Well, very much so. Very much so, my lord. So the order is in the supplemental bundle, divider 25.
Thank you. So we're now looking at the particulars of claims served in consequence of that order.
We are. So they're behind divider 8, page 74. There's only a few points to pick up here in particulars. 5. Kajima carried out the works necessary to rectify the defects at its own expense, and these works finished around March. Nevertheless, CAP has suffered a loss because the trust has asserted deduction. Paragraph 7, the latest figure provided by the trust for deductions is a little under 14 million, and CAP has suffered its own direct losses. 8, CAP seeks to recover these losses as damages for breach and or pursuant to a contractual indemnity. Paragraph 50, my lords, at page 89. Paragraph 50, as a result of the matters set out above, those are, of course, the allegations of defective work. CAP has suffered losses falling into 2 categories. 50.1, liability for contractual deductions levied by the trust. And 50.2, CAP's own costs of investigating and dealing with the defects. Then at paragraph 53, CAP explains how it understands that the trust makes its claim for deductions, which is straightforward enough. And then over the page, 55, CAP claims against Kajima as damages its actual liability to the trust, or if it's compromised, that sum that it agrees to pay and any ancillary costs. Then there's a claim for CAP's own costs. Paragraph 58, page F92. Again, really a repeat of how the claim is formulated, and then at 59, alternatively, the claim is claimed by way of indemnity. Finally, and I'll pick this up when I look at the guarantee aspect of the appeal, 64, in the premises, insofar as Kajima is found liable to CAP as set out above, Kajima Europe, the guarantor, will also be liable pursuant to the terms of the guarantee. I'll come back to that aspect of the appeal in due course. So, my lords, that completes the second part of my submissions. I've been through the contracts and I've been through the correspondence. Well, as I said,
Did either CAP or the trust refer the dispute between them as to the deductions to the liaison committee at any stage?
My lord, I'm not aware of the answer to that question. I don't know. Now, your lordships, I hope, have the authorities bundle. I said I'd say a few words about the law. The judge has already found that CPR Rule 11, Part 11, was engaged, subject to the question of enforceability. And in her judgment, at paragraph 59, forgive me, my lords, the judgment is in the core bundle behind divider 5.
Paragraph 59, did you say?
Yes, please.
Page D52.
Yes, paragraph 59, the court said that it was common ground at the hearing that if it is to be enforceable, the DRP must be sufficiently clear and certain by reference to objective criteria. And then the learned judge referred to both Holroyde, decision of Mr. Justice Ramsey, and also to Tang, decision of Mr. Justice Childrens, which we'll look at in a moment, in relation to that. So if I may, my lords, I'll briefly go to Holroyde, then a case called Open, and then Tang, and I have a few observations to make about the law. My lords, Holroyde is in the authorities bundle behind divider 9. I merely want to take your lordships to the relevant passage, which is at paragraph 81, at page 671 of the report. Mr. Justice Ramsey had examined a number of the relevant authorities, and in paragraph 81 he said, "It seems to me that considering the above authorities, principles to be derived are that the ADR clause must meet at least the following 3 requirements. First, that the process must be sufficiently certain in that there should not be the need for an agreement at any stage before matters can proceed. Secondly, the administrative process for selecting a party to resolve a dispute should be defined. Thirdly, the process, or at least a model of the process, should be set out so that the detail of the process is sufficiently certain. My Lords, then open appears behind divider 13. This is a decision of Mrs. Justice O'Farrell. The first observation to make about this case is that limitation was not an issue, and therefore it came as no surprise that a stay was applied for in relation to the failure to follow the dispute resolution process, and a stay was granted. The fact is that in this case nothing else was at stake. So turning up the paragraph 27 of the report, please, page 580. Oh, forgive me, I'm looking at a different report, so the page numbers will be different. But paragraph 27, if I may, page 792 of the All England version. First of all, something I referred to when I was setting out the landscape of the appeal. Paragraph 27, it's common ground that a clause requiring the parties to follow a specified dispute resolution process can in principle create a condition precedent for the court proceedings. But in paragraph 28, Her Ladyship looked at the decision of Mr. Justice Coleman in Cable and Wireless. And there are a few points that I'd like to pick up in that quotation, please. So first of all, in the numbering of Cable and Wireless, paragraph 21, essentially the question that arises is whether the reference is in substance nothing more than an agreement to negotiate, and as such an agreement incapable of enforcement in English law. Skip a few lines. In this case, they have gone further than that by identifying a particular procedure, namely an ADR procedure as recommended by the parties by the Centre for Dispute Resolution. 3, there's obviously a lack of certainty in a mere undertaking to negotiate, just as there is in an agreement to strive to settle a dispute amicably, as in the Paul Smith's case. That is because a court would have insufficient objective criteria to decide whether one or both parties are in compliance or breach. So on, 24 explains that CEDA is cited. My Lords, paragraph 28, this important point in relation to public policy, for the courts now to decline to enforce contractual references to ADR on the grounds of intrinsic uncertainty would be to fly in the face of public policy as expressed in the CPR and as reflected in the judgment of the Court of Appeal in Dunnet. And then this passage at 32, in principle, where there is an unqualified reference to ADR, a sufficiently certain and definable minimum duty of participation should not be hard to find. We do rely on those words, and in a moment I'll look at Tang, where those words are discussed. So moving on through this judgment, though, for the moment, paragraph 31, if I may, Her Ladyship again makes reference to the public interest in the enforcement of agreed ADR provisions, and in this case she refers to the Emirates trading case. And the quotation there says, enforcement of such an agreement when found is in the public interest, first because commercial men expect the court to enforce obligations which they have freely undertaken, and second because the object is to avoid what might otherwise be an expensive and time-consuming arbitration. And then Her Ladyship, paragraph 32, sets out the principles which she derives from her review of the authorities. First of all, the agreement must create an enforceable obligation. The obligation must be expressed clearly as a condition precedent. Now, the judge below took issue with that point, but it needn't concern us for present purposes. And 3, the dispute resolution process to be followed does not have to be formal, but must be sufficiently clear and certain by reference to objective criteria, including machinery to appoint a mediator, and so on, and then reference to the court's discretion to stay proceedings where there's been a breach of the dispute resolution procedure. My Lords, the next case to look at is Tang. That can be found behind divider 11. This was a decision of Mr. Justice Hildyard, and in paragraph 49, which is on page 1236 of the report, your Lordship will see reference paragraph 49 to Lord Justice Morbick in a case in which they quote again, or refer to at least, cable and wireless. Paragraph 50, Lord Justice Morbick concluded, if I think mediation is not defined with sufficient certainty, the conditions cannot constitute a legally effective precondition. 51, partly because of Lord Justice Morbick's reference to it, but also because it illustrates that the court will seek to give effect to provisions intended to bind the parties as far as possible, and may even enforce part of a commitment through the whole, though the whole cannot be enforced. I should also address the cable and wireless case. And then he goes on to do so. And over the page 1237, middle of the page, paragraph D, Mr. Justice Coleman held there was an obligation on both parties to participate at least to the extent of cooperating in the appointment of the mediator and attending at least one meeting. And then Mr. Justice Hildyard quotes the passage that we have already looked at, last sentence of that passage. In principle, however, where there is an unqualified reference to ADR, a sufficiently certain and definable minimum duty of participation should not be hard to find. And then in paragraph 52, his Lordship expresses some puzzlement in relation to that last sentence. However, we in our respectful submission, do not share any such puzzlement. We respectfully adopt the contract saving observations of Mr. Justice Coleman, and what he was saying in our respectful submission was simply this, that it is surely not beyond the courts to find in an unqualified reference to ADR sufficient for such a provision to be found enforceable, in accordance with, of course, the strong public policy interest in the enforcement of ADR provisions.
So is it your case that there does have to be identified a sufficiently definable minimum duty of participation?
Yes.
And you'll help us in due course with what that is in our
yes.
case.
My Lords, if we turn on to page 1239 and 58, 59 and 60, we find ourselves in respectful agreement with a good deal of this. Paragraph 58 says this: however, especially where the relevant provision is but one part of a concluded and otherwise legally enforceable contract, the court will strain to find a construction which gives it effect. For that purpose it may imply criteria or supply machinery sufficient to enable the court to determine both what process is to be followed and when and how, without the necessity for further...
So sorry, it's my fault, I was just making a note. Which paragraph are we on
58.
Now? Thank you.
I'm so sorry.
Thank you.
For that purpose it may imply criteria. So the provision, second line, paragraph 58, the court will strain to find a construction which gives it effect. For that purpose it may imply criteria or supply machinery sufficient to enable the court to determine both what process to be followed and when and how, without the necessity for further agreement, the process will be treated as successful, exhaustion, or properly terminated. The court will especially readily imply criteria or machinery content of stipulation for a fair and reasonable price. We're not concerned with that. 59, the court has been in the past and will be astute to consider each case on its own terms. The test is not whether a clause is a valid provision for a recognised process of ADR. It is whether the obligations and or negative injunctions it imposes are sufficiently clear and certain to be given legal effect. And then in paragraph 60, the judge goes into a little more detail as to what he regards the test to be. In our respectful submission, that is that there is at least an element, perhaps, in that passage of over-prescriptiveness. But, my Lord, we say nothing really turns on that because the contract complies with those requirements of the event. Can I ask your Lordships to turn to my skeleton? There are certain principles referred to in paragraph 11. I'm not proposing to take your lordship to these authorities, we've cited Lewison, we've cited Gillas, and we've cited Anglo-Continental. Essentially, I'm quite sure your lordships are familiar with this submission, that the law should be the upholder rather than the destroyer of bargains, of course. And where an agreement is not well drafted, a principle which has particular potency and resonance is that if the agreement is susceptible of an interpretation which will make it enforceable and effective, the court will prefer that interpretation to any interpretation which would result in its being void. So I don't propose to turn those up. Lord, there is one authority which I will turn up, referred to in paragraph 30 of my skeleton, and that's a steamship mutual case. The observations made in that case by Lord Justice May are every bit as relevant today as when they were made 37 years ago. My lords, that's behind divide of 2 of the bundle authorities. Lordships could turn to page 81 of the report. Lord Justice May. This is another of an increasing number of large building claims that are now coming before the court, whether it be the complication of modern building methods or whether nowadays defects take longer to show than they did some years ago, whether it's attributable to the general lack of haste, which seems to be endemic in this type of litigation. This is yet another case also raising problems under the Limitation Act. Those problems Parliament and the courts have for many years tried to solve. At the root of the difficulty is the obligation or desire to be fair to the plaintiffs on the one hand. You are seeking to recover in respect of matters which of necessity may appear some time after the original transaction. On the other hand, the desire to be fair also to the defendants, who may have to investigate allegations made against them years after the event. But let it not be forgotten fair also to society generally, whose interest is to see a finite end to litigation. For my part, I would add that it's not always the interest of a party seeking to recover, or indeed of a party defending, which throughout deserves paramount consideration. The nearer one gets to the end of the limitation period, the more important becomes the interest of the public generally to see these disputes disposed of. And then the passage which is quoted in our skeleton is to be found at page 88. Two-thirds of the way down the page, at the end of the large paragraph of law. Good justice needs to be swift justice. And in my opinion, the limitation period is provided for by the Limitation Act 1980 is generous. Any artificial extension of those periods needs to be fully justified. The last case which I'd like to look at before I make my submissions on the appeal is the case of Snooks. And your lordships will find Snooks behind divider 7. This is a decision of Mr. Justice Silber, and if your lordships take up the reference at H3 on the first page, the H3 is on the left, the agreement between the parties provided as follows, fourth line. Save as provided herein, any proceedings arising out or in connection with this agreement shall be brought in a court of competent jurisdiction in London. And then, if your lordships, and we're still in the headnote, can turn to page 436, bottom paragraph, H16. This is a summary of what the court decided. What happened was, instead of issuing proceedings in London, the proceedings were issued in Swansea. H16, as to the question of the proper procedural course, whether a transfer of proceedings or a stay, applying the principles in international cases, it would not be right to transfer the proceedings to London, because that would mean the claimants would be placing themselves in the same position as if they had instituted proceedings in accordance with clause 27.14, i.e. in London. The defendants were entitled to have claims such as those made in the proceedings at issue commenced in London, and the claimants had no right to avoid that requirement. The only basis on which an order could have been made transferring the claims to London would have been that that was required because of the overriding objective of the CPR of dealing with the case justly. That objective would not be met by transferring the case to London for two reasons. First, such a course might deprive the defendant of the limitation defence. And secondly, there was nothing unjust about requiring parties to comply with their contractual obligations. Thus, the defendants were entitled to have the present claim form set aside. And this is a case where that determination was made precisely as we are asking here, in the teeth of limitation and under CPR Part 11. So can I just take your lordships to the substance of the decision, which is at page 453. Beginning under the heading The Remedies Issue, paragraphs 63. Mr. Evans-Tovey submits that because of those various articles, which we are not concerned with in the present case, the proper and appropriate remedy for the defendant is for a declaration that the court in Swansea had no jurisdiction in either action, and the present claim form should be set aside or the action stayed. Mr. Butler, and then two lines down, orders should be made declining jurisdiction. He submits that the appropriate additional remedy is not the claim form should be set aside or stayed, but they should instead be transferred to London. And in this case, the language of stay was to similar effect as is being discussed in the international cases. So, in other words, it's a stay for all time. It's not the sort of stay that we would be talking about in this case, where one can have the time to go to the dispute resolution and then the action is resurrected. So that was the nature of the stay that was under discussion.
When you say in international cases?
The discussion follows in this part of the judgment, Lord. I'll show you what I mean. So the relevant provision is CPR Part 11, and that's there set out. An order containing a declaration that the court has no jurisdiction or will not exercise its jurisdiction may also make further provision, including A, which is the one that we rely on setting aside the claim form, or D, staying the proceedings. 66, Mr. Butler accepts that this doesn't include any provision for making a transfer, but he says that a transfer is an order that could be made. And the judge takes that as an assumption for the purposes of his decision making. And then under the heading discussion, neither counsel was able to provide any authority on how a court should deal with an unusual case such as the present one, in which the dispute was not a choice between the jurisdiction of the English courts and the jurisdiction of the courts of a foreign country, but instead a choice between different courts in Great Britain. I agree with Mr. Evans-Tovey, however, in resolving this issue, it's possible to attain some assistance from the principles applied by the courts in cases where a claimant sues in this country in breach of an agreement to refer the relevant disputes to a foreign court. Now, of course, we're not concerned with that debate, but in paragraph 69, the court examines the question by reference to a test for a strong case. And so that's what's being discussed in paragraph 69 and 70. And in paragraph 70, 4 or 5 lines down, this submission is recorded. It is said by Mr. Butler that in the present case, the defendants are trying to take advantage of a limitation point in Mr. Snook's case, as his claim may become partially statute barred if jurisdiction in Swansea is declined. Then there's further discussion of the international cases, and then in paragraph 72, the judge says, in my view, a similar approach should be adopted in non-international cases, such as those of Mr. Snooks and Mr. Little, with the result that an issue that is now to be resolved is whether the claimants can show that they acted reasonably in not issuing proceedings in London to protect their position before the expiry of the primary limitation periods. And the judge goes on to find that Mr. Snooks and his advisers cannot show that they've acted reasonably in not issuing proceedings in London for 6 reasons. First, Mr. Snooks only issued his claim against the defendants at or after the end of the limitation period for some of his causes of action, with the result that he must therefore take the risk of limitation problems arising. Secondly, there was nobody asked whether clause 27.14 could be waived. The reason they were not issued in London was because the matter was not in the forefront of the solicitor's mind, and there was no explanation as to why they were not issued in London. And 4th, 5th, and 6th, there are no obvious disadvantages to claimant issuing proceedings in London. Now, of course, we're not quite on all fours in this case, because his lordship was asking himself whether the claimants can show they acted reasonably in not issuing proceedings in London. But nevertheless, we say that the court's analysis of the question, and in particular the fact that it exercised its discretion under CPR 11 up against limitation, we say that the reasoning process which the court adopted is relevant. And in particular, the fact that no good reason was shown for proceedings being issued in Swansea instead of London, and the fact that Mr. Snooks took his own risks in doing what he did, hard up against the expiry of limitation. And so at 74, the judge arrived at the stage where he said, in my view, this is a clear case in which there should either be a stay of the proceedings or the claim form should be struck out. The claimants would then be obliged to comply with 27.14, which, for the reasons I've sought to explain, require the present proceedings to be brought in London. This is a contractual precondition with which the claimants have to comply in the absence of a strong case for doing so. We're not concerned with that particular test. Nevertheless, it was a condition which they have to comply. They wish to see the defendants. It would be wrong to permit the claimants to bypass this requirement in the absence of a strong case for doing so. In reaching that conclusion, I've not overlooked Mr. Hitchcock's contention that the defendant's application amounts to procedural manoeuvring. But in my view, there is nothing improper or questionable about a party invoking a clear contractual provision, such as clause 27.14, especially if the party complaining about its effect has not been able to state that he would not have entered into the agreement if he had been aware of it. 75. So it would not be right to transfer the present proceedings to London, because that would mean that the claimants would place themselves in the same position as if they had, in effect, complied, which is a course which they could and should have, in my view, have adopted, but unfortunately they've not done so. And then, towards the end of that paragraph, the reasoning which is extracted into the head note, 5 lines up. In my view, this objective would not be met by transferring this case to London. That's the objective of dealing with cases justly, for 2 reasons. Firstly, such a course might deprive the defendants of a limitation defence, and secondly, there is nothing unjust about requiring parties to comply with their contractual obligations set out. Therefore, the defendants are entitled, the reason which I've given, to set the claim forms aside. So we do place reliance on that case, which is it was approached differently by the judge because it was a jurisdictional type debate in terms of where proceedings were issued. But we say that the result which the judge arrived at was compelling, and we in our respectful submission, the same result should be arrived at in this case, for reasons which I'm about to come on to when I make my submissions.
Forgive me for interrupting. I understand entirely what you're saying in that respect.
Yeah.
But there's something that's troubling me slightly, which might have some bearing on ground 2.
Yes.
I think you submitted that in the international cases, a stay was used in the sense of meaning dismissal rather than temporary stay.
Yes.
And I wonder whether that's right. Often in disputes, jurisdiction disputes, whether they're on a foreign convenience basis or whether they rely on a foreign jurisdiction agreement, a stay is the usual form of relief, but my understanding is because that is the reason for that is that the stay may be subsequently lifted depending on events in the foreign jurisdiction.
Yes.
As to whether they accept jurisdiction or not.
Yes.
And my instinct is, although I don't have the authorities at the front of my mind, that dismissal is only the remedy that is applied in those cases. I think unusually, but sometimes, when it is clear that there will be no problem with the dispute being resolved in the foreign jurisdiction.
Yes. Well, forgive me. What I did clumsily and incorrectly was to try and explain why that discussion was taking place at all in the Snooks case. It isn't material to the present case, and so forgive me if I diverted the court in that manner.
And whilst I've paused, there may be a question as to whether Mr. Justice Silver was right to apply the international cases by analogy, I myself appeared once in front of Mr. Justice Robert Goff, as he then was, to argue a similar point.
Yes.
And he held that the international cases had nothing to do with allocation of domestic jurisdiction. It won't have been reported, and it obviously didn't come to the attention of Mr. Justice Silver. But that doesn't undermine any of your submissions, but I thought I should mention that.
No, well, my lord, thank you very much for mentioning that. I'm inclined to agree. Really, the reason for going to Snooks is quite simply to say that the judge there had a similar question, which I will, in the event, be inviting your lordship to determine what's to be done. Is it to be stayed or is it to be set aside? And I'll come to that when I make my submissions on ground 3. So, my lords, after that quite lengthy introduction, do forgive me, can I come on now to my submissions, starting with ground 1. And I wonder whether it might be convenient, although I have taken your lordships to them in, as it were, the raw documents, I did take the opportunity of appending the relevant clauses to my skeleton. And your lordships may find it easier to have Appendix 1 open, so that you can readily refer to those provisions instead of going backwards and forwards to the supplemental bundle. The court may also wish to have open, in case your lordships wish to raise any questions, the judgment below at paragraph 61, where the learned judge dealt with paragraph 61, where the learned judge dealt with the question of enforceability. I'm sure your lordships have it, but it is in the core bundle at divider 5. So with those preparatory measures underway, my lord, so far as ground 1 is concerned, we make these submissions. We say that the ADR, the DRP provisions are sufficiently certain to be enforceable. They are sufficiently clear to afford a simple, straightforward and time-limited process of ADR. They are also perfectly sufficient to permit the court to determine whether or not they have been complied with. And in our skeleton, we have gone into some detail by reference to each of the learned judge's observations in subparagraph 61.1 to 61.5 of her judgment. Let me, instead of wading through all that material again, let me try and summarise the position in stages as follows. First of all, let us examine the terms of the procedure. The process is a referral of the dispute to the liaison committee. That we see in clause 3.1. The liaison committee convenes and seeks to resolve the dispute within 10 business days of referral. That is clause 3.2. Then moving on, if your lordships are in my skeleton appendix 1, the function of the liaison committee is, quotes, I'm looking at paragraph 12.2c, is, quotes, to provide a means of resolving disputes or disagreements between the parties amicably. Over the page, the liaison committee may invite Kajima to attend. We find that in paragraph 12.5a. And also in paragraph 12.5, we find that the procedures and practices for the conduct of the reference are such procedures and practices as the liaison committee considers appropriate from time to time. Back a page, and if the dispute is not finally resolved, then it shall be referred to the High Court, and that is clause 7.1. So those are the clauses and that is the procedure. Second, let us ask ourselves whether that procedure provides sufficient certainty and whether the procedure can, in due course, if necessary, be examined for compliance.
So I'm sorry to interrupt you, but can I just be clear?
Yes.
Is the condition precedent on your case, is it the commencement of this process or is it the completion of this process?
It's It's both. It's the commencement and
completion.
Yes.
So you can't go to court until the process has been completed.
No, and I'll come on to when that is in a moment.
Thank you.
I should add, my lord, that the process may turn out not to be completed, because the way the clauses operate is to provide certainty by point in time. So if your lordship looks,
The process may not be completed.
yes, yes, because my lords, paragraph 3.1 provides for a referral to the liaison committee. Paragraph 3.2 provides for the dispute to be sought to be resolved within 10 business days, and then 7.1 provides that all disputes to the extent not finally resolved pursuant to the procedures set out above, a party may then refer the matter to the High Court. Now, of course, the parties are always at liberty, and your lordship saw reference in the correspondence to a proposal by the respondent to have a 2-month period, for example, for the resolution of the dispute. And what commonly happens in these contracts is that the parties agree usually a much longer timetable for the process to unfold. But the answer to your lordship's question is, if the process has not, if that doesn't happen, and the process has not, if the dispute has not been finally resolved after the passage of 10 days, then either party is then free to refer the matter to the High Court.
But that's not the completion of the process.
Well, it may or may not be. The way we put it in our skeleton, let me just turn that up, Lord. Paragraph 19. In fact, it is obvious that the process comes to an end once the 10-day period identified in paragraph 3.2 of Schedule 26 has elapsed, or earlier if the dispute is resolved, or not resolved prior to that. So there are several ways that matters might unfold. Once the 10 days is up, a party is entitled to take the matter to the High Court.
That way of putting it means that the process is over after 10 days, unless the parties agree to extend it. But absent agreement, the process is only a 10-day process.
Exactly right. Yes.
So when you say the process may not be completed,
Yes.
I still don't understand what you mean by that.
Well, your lordship is right that the process, whether successful or otherwise, is a 10-day process. That's, I think, the submission.
And how do you square that with the requirement that you have to give at least 10 days' notice to convene a meeting, save in an emergency? .10.
Well, what your lordship has to do is read the two clauses together, and clause 3.2 of the construction contract makes clear that the obligation of the liaison committee is to convene and seek to resolve the dispute within 10 days.
Right, but the liaison committee only has the powers and functions which are conferred upon it.
Yes.
In the project agreement, and by adoption of the definition, the same powers for the purposes of the construction contract. So does that mean you have to treat all references under Schedule 26 as emergencies?
My lord, that would be the way of resolving the conflict, the apparent conflict between the two clauses. But of course, there's a simpler way, which is this, that clause 3.2 is addressing very specifically the question of the obligation of the liaison committee in connection with a construction dispute. So it may be, because your lordships will see that in paragraph 3.1 there is simply a general reference to the referral of a dispute to the liaison committee, whereas 3.2 begins where a dispute is a construction dispute, the liaison committee will convene and seek to resolve the dispute within 10 business days. And my lords, the same provision appears in Schedule 26 of the project agreement, and so reading it together, both in the project agreement and in this agreement, and thus binding the trust and its members of the liaison committee, one can readily see that because 3.2 addresses the matter of a construction dispute specifically and head on, then the obligation in 12.10 must be read subject to the requirement in 3.2 that the liaison committee will convene, so there's the power of convening, and seek to resolve the dispute within 10 business days.
And how does this work for things other than construction disputes? When is the process complete if it's not a construction dispute?
That is not a question that I've addressed my mind to. Perhaps I can come back to it. But on the face of it, it would appear that express provision is not made for the conclusion of that process, and therefore the process would conclude, I'll have to give this some thought, but either after a reasonable period has elapsed, or after it is clear that no resolution is possible, or after resolution has taken place.
Is it your contention that this is sufficiently certain to be enforceable in relation to non-construction disputes?
Well, I haven't advanced any case in relation to that. My position is that this procedure is enforceable in relation to construction disputes. And the question for this court is whether it's enforceable in relation to construction disputes. But I will give your lordship some thought. I certainly don't have a case that this is not enforceable for the purposes of a non-construction dispute, for reasons which I'll come on to. But generally, that the court should strive to uphold the bargain, where it can. Machinery can be implied, terms can be implied to rescue a process if the process is encountering some difficulties, which we don't at this stage accept in relation to non-construction disputes. But my lord, I'll have to go off and give some thought to that question.
Thank you.
Well, Mr. Hargreaves, when you're reflecting on that, could you also please reflect on paragraph 7, or clause 7.1, which, on the face of it, rather jars with your submission a moment ago that after 10 days either party is free to commence litigation. 7.1 seems to require the issuing of proceedings.
Yes, my lord.
Perhaps you could reflect on that as well.
Yeah, indeed. Thank you. Well, now, having examined the terms of the procedure, my lords, what I was then going to do was to come on and ask whether the procedure provides sufficient certainty and whether the procedure and the process can be examined in due course for compliance. And in our submission, the simplest way of doing that is to consider the position by reference to the stages which a dispute might follow as it unfolds. So, for example, the first stage, whether or not a matter has successfully been referred to the liaison committee, is the type of issue which the courts consider frequently. It's a question of fact, and here one simply would need to ascertain whether the dispute had been formulated and then whether it had been referred to the liaison committee. So in our respectful submission, there's no difficulty identifying whether a referral has taken place. Secondly, whether the liaison committee has in fact been convened is easy enough to identify objectively. It is again a simple question of fact. And my lords, the overall function now of the liaison committee is also expressly defined. It is to provide a means of resolving disputes or disagreements amicably. Now, my lord, the liaison committee may or may not discharge that function successfully. Various observations are made in the judgment and the learned friend Skeleton concerning the challenges which the liaison committee may face in this respect. One of those is the permanent membership only comprises the trust and project code. True enough. But my lords, whether or not the liaison committee successfully discharges its obligation is not the same as whether the obligation is part of a sufficiently certain ADR procedure. And there's a related proposition as well, which is that one might say to oneself, well, the utility of this procedure is not easy to identify. It doesn't seem likely to operate successfully where Kajima isn't, for example, a member of the liaison committee. But questions of utility are not material. The only question is whether or not the procedure is sufficiently certain so as to be enforceable.
They're not material under ground 1. They may be very material under ground 3.
Well, I'll come on to ground 3, but my lords, in our
I
respect...
mean, if it's a condition precedent to comply with a completely useless process, that may be relevant to the exercise of discretion.
Well, first of all, my lords, we don't accept that the process is...
I understand that, but I'm just testing the proposition. You said it's not material, and I'm suggesting it may be material under ground 3, even if you're right that it's not material to ground 1.
my lord, yes. Now, so, in essence, whether or not practical compliance with the obligation may or may not present challenges is one thing, whether the obligation is clear is another. Now, of course, furthermore, the liaison committee may invite Kajima to attend under its powers in clause 12.5, and it would be surprising, assuming that the liaison committee took its function seriously, if it didn't invite Kajima to attend in relation to a dispute which involved Kajima. But again, even if it didn't invite Kajima, that goes to whether the obligation to provide the means of resolving the disputes was discharged.
But if as you are not conceding, but I think recognising, it is likely to be impractical for the liaison committee to have convened and involved Kajima in a way which involves performing its functions under 12.2c, that is, attempting to resolve it amicably, which must include Kajima participation. If in practical terms that's likely to be impossible, that may suggest that your construction is wrong, that the process is not one which is, the parties have agreed, will be over in 10 days.
No.
All that has been agreed in 3.2 is that there will be a convention of the liaison committee in order to seek to resolve. And the process may then go on in different ways and over a longer period.
Well, there are several points to make about that. First of all, is the construction likely to be wrong because it appears to be a short period? My lord, no, respectfully. One sees all the time in contracts like this, particularly PFI contracts, in a series of time periods which are, on the face of them, short. But that is what the parties have agreed. What happens in practical terms when disputes unfold is that the parties sit down and agree to have longer periods for the process to unfold, just as the respondent suggested in correspondence when looking for a stay to apply the liaison committee procedure, that it be 2 months and not 10 days. There was recognition that the period was short and it would be better to have a longer period. So, my lord, we do not accept that the mere fact that the period is short means that the construction of that clause is incorrect. And the second point is that we've looked at the authorities and they're clear in saying that where a court has a choice in relation to construing a provision, it should prefer the construction which saves the provision and the accompanying machinery, rather than the construction which renders it void. We say that the very question your lordship is asking, and there's another question I'll come on to, we say that that very question your lordship is asking is an occasion where one should choose the reading of the words that's clear and certain. And it is obvious that the parties have been doing that, and it is clear and common in many other cases involving PFI contracts, which have these very short timescales, that parties do that. But it doesn't challenge the underlying term that's there.
I understand that submission in the context of your submission that it's the completion of the process which is the condition precedent, not the commencement of the process.
Yes.
That wouldn't render the provision no utility or uncertain if the condition precedent were merely the commencement of the process. So if the process is one which will not necessarily be completed within 10 days, but what you have to do before you go to court is at least invoke the process, which is a process for amicable resolution. Therefore, it's like a mediation in a way. It can't impose a solution on an unwilling party. Come back to that, but assume that's what it is.
Yes.
Might it be the case that what this condition precedent is doing is saying, if you want to go to court, you have got to have invoked this process. You needn't wait for it to finish. It can be going on at the same time. No one knows quite what form it's going to take or quite how long it's going to take.
Yes.
But there may be utility in that because the court can exercise case management depending on what's happening.
Yes.
Now, I throw that out because although that's not your case, it might be one way in which utility could be given and a construction given to it, which might be one which is realistic.
Yeah. Well,
vis-a-vis Kajima's participation in the process.
My Lord, respectfully, that's a very helpful reiteration of the point which your Lordship made a little while ago, which I was perhaps too obtuse to pick up. It's not a million miles from my case. My case is certainly the procedure has to be invoked and commenced, but I did, in replying to your Lordship's question, say that the procedure may not finish, because as your Lordship says, it is unclear whether the process will or will not finish, because it depends what happens.
Well, I'm not sure what that... The process will finish at some stage.
Yes.
But that isn't that can be consistent with it being referral, which is the condition precedent,
Yes.
i.e. commencement of the process, not completion of the process.
Yes. Well, my Lord,
You clearly said that wasn't your case, and if it's not your case, we won't need to consider it further. But it is a construction which has been floating through my mind.
well, my Lord,
If you want us to consider it,
yes, my Lord. Yes, I do. It may be that I answered your Lordship's question too bluntly and then sought to qualify my answer. It seems to, in our respectful submission, it is a possible construction of the condition precedent, that it merely requires the initiation of the process before proceedings may be begun. So yes, we do invite your Lordships please to consider that analysis.
Can I just be clear? Are you saying that an alternative possible construction is that it requires a party who's wanting to litigate to send a letter?
To send
A letter to the liaison committee?
to identify the dispute, a letter, and to refer it to the liaison committee. That's what the language of the clause is required.
Yes, but that simply means sending a letter.
It certainly could amount.
And then going and issuing proceedings half an hour later.
On that construction, yes.
Okay. Thank you.
So your Lordships will recall that I was going through the process of examining whether or not the process could be looked back upon in order to see whether or not it had been appropriately gone through and discharged. And in our submission, so far as that's concerned, yes, it's perfectly clear. The procedures and practices are such procedures and practices as the committee considers appropriate. That's 12.15. And again, the court is perfectly well placed to consider and determine whether those procedures and practices which were adopted were in fact appropriate. And again, it may or may not be the case that the committee does apply appropriate procedures and practices, but that doesn't mean that the obligation to do so is unenforceable. And then so far as the end of the process, our primary case is that the process is time limited. if the dispute, the only question that needs to be asked is, has the dispute been finally resolved within 10 days? And if it hasn't, then either party may commence those proceedings. And your lordships, I've already made my submissions about preferring the construction, which generates certainty, as opposed to a construction which does not. There is, of course, then the question, has the dispute been finally resolved? And again, courts, as part of their everyday business, are often asked to determine that question. One party thinks that the matter is resolved, another party thinks it's not. It's a question of fact. The criterion is straightforward. Has it finally been resolved, or has it not? And so, for those reasons, my lords, we say that the dispute resolution procedure is not unenforceable for uncertainty, and respectfully, that is the conclusion that one would expect to arrive at in relation to a dispute resolution procedure in a relational contract set to operate for a period of 30 years.
You've mentioned relational contracts. Does it actually make any difference whether it's a relational contract or not?
Well, only that it would be a surprising and unfortunate outcome that a contract that was set to run for 30 years was...
Well, that's the project agreement.
Yes.
We're talking about Schedule 26 under the construction contract.
Yes. But many of the criticisms that are made going to unenforceability of the dispute resolution procedure apply equally to the project agreement.
Yes. Well, that I follow, but I mean, this is just a standard building contract with a 12-year limitation period.
It is, yeah.
And the characterisation of something as a relation contract is usually invoked in order to imply an obligation of good faith. I think you said you were going to come back to this. What is the definable minimum duty of participation in this case, to adopt Mr. Justice Coleman's words in Cable and Wireless that you adopted?
Well, it is.
What does Kajima have to do as its minimum duty of participation, or indeed cap?
Well, it's what one's looking at is the procedure, and so the first question is who is referring the dispute to the liaison committee, and the procedure is certain. Whether Kajima is involved in the procedure or not will depend upon whether Kajima is invited to attend the procedure. There is that power under paragraph 12.5a. The remainder of the procedure is sufficiently certain to be enforceable. The extent to which Kajima participates will in the first instance depend upon whether it's been invited to participate.
I suppose it has.
Well, then it's a matter for Kajima what it then does in relation to that. But the court presumably will conclude that provided... the only question which the court is asking is whether or not within a 10-day period the dispute has or has not finally been resolved.
Well, I thought you adopted what Mr. Justice Coleman said in Cable and Wireless, that you have to at least have a definable minimum duty of participation.
Yes, and that, but my lord, that will
so
be...
So if Kajima's invited, is it entitled to say, I'm not interested in coming?
Yes, it is.
So what is the duty of participation? No, none.
Well, the process, if it's Kajima's dispute, then the process is that it will be referring its dispute to the liaison committee. If it's Project Co's dispute, then it's Project Co that we're referring the dispute to the liaison committee. And how events unfold after that, it depends upon what happens. But so far as the participation there is concerned, that's the participation of the Trust and Project Co in the dispute that has been sent to them by whichever party has referred the dispute.
Surely if there is a minimum duty of participation as a condition for it to be sufficiently certain to be enforceable, and it is a mediation process in which the tribunal can't impose a decision, it must mean duty of participation of both parties, mustn't it?
Well, I can only answer that question by saying not necessarily, in circumstances where it's unclear whether Kajima would or would not be invited if this was a dispute referred by project code. The emphasis of...
I'm sorry, Mr. Holroyde. Does that mean that you contemplate under the procedure that Kajima may literally play no part whatsoever?
Yeah, that is contemplated.
May not even open the letter from the liaison committee inviting them?
Well, I don't know about that, but my lord, it's certainly contemplated by this procedure that Kajima may not be invited to attend the liaison committee. Now, again, as I have submitted, that may be something that raises one's eyebrows, but it is hypothetical. In the real world, it's likely that Kajima will be invited if the dispute involves Kajima, and in the real world, it is likely that Kajima will attend. And in our respectful submission, what one ought to be doing is not, in circumstances like these, with an ADR procedure entered into by the parties, which presumably one imagines they hoped would operate successfully, in our respectful submission, it's less appropriate to go through it, looking for hypothetical holes and difficulties that may appear, where one is simply being asked at a much more general level whether the procedure is sufficiently certain to be enforceable. And at an overall level, we have submitted that the procedure is sufficiently certain to be enforceable, whilst acknowledging that it is certainly an unusual procedure, and that in the event it is at least possible that it may not be as useful as certain other procedures might be, as written. But I do emphasise that the parties in the real world will do all that they can in usual circumstances to make the thing work. And I do emphasise in the correspondence that it was the respondent who now argues that the procedure is unenforceable, who is encouraging the utilisation of the procedure.
Whilst I've blown you, of course, can I ask you something else? I'm sorry.
Please.
Clause 3.1. Any decision of the liaison committee shall be final and binding. What content do you give to that?
Well, my lord, the answer to that, and it's certainly her ladyship below 61, paragraph 61, subparagraph 4, referred to that. And a question is, well, who are the parties? Is it the trust and CAP? Is it Kajima and CAP? Or is it all three? It's true that it's not easy to answer that question. But my lord, just as with the other objections that are raised to the procedure, puzzling about the meaning of that clause does not go to the certainty or otherwise of the dispute resolution procedure.
Well, it's fairly fundamental to defining what the process is that we're looking at. It's one thing to say, well, essentially you've got to ignore that because there's nothing that the liaison committee could do to impose an unwilling solution on Kajima.
No.
It's another that you give that some content and you recognise that in some circumstances, for example, if there's a unanimous vote of the liaison committee, that is a decision which will bind Kajima. And I am interested in which you say is the right construction. And if it's the former, how you reconcile that with the language in 3.1.
Well, my lord, our position is that the question which your lordship raises, it does not go to the certainty of the procedure. It goes to the quite different question as to the enforceability of any decision that the liaison committee may make. That question doesn't arise on this appeal. Nobody suggests that there has been any relevant decision, still less whether any such decision is final and binding. So, my lord, our submission is that the question simply doesn't arise. The question for the court is whether the procedure is sufficiently certain, a question about what that sentence means goes to the enforceability of any decision that the liaison committee may make.
Well, the reason I think it may be relevant is that if this is essentially a process which is only ever a talking shop, if I can put it that way,
Yeah.
then it may be easier to say, well, you haven't got to wait for a decision. If, on the other hand, it's a procedure in which a decision will be binding in some circumstances, there may not be a decision, but there may, and you've got to wait until the process has made clear whether there is or isn't going to be a decision, then it may be rather harder to say, well, it's completion of the process and the process is all over after 10 days, even if they're still going through the process at that stage. That's why I asked the question. But
Well, yes, my lord, but
if there's any more you want to say, do just.
no, okay, well, no, my lord, but after the 10-day period has expired, or my primary case is the correct instruction, the parties then go, one or other party may then take the matter to litigation. There may then, in due course, be an issue in the litigation as to whether or not the matter was already determined in a way that which was final and binding. That question may arise. At that point, then another question may arise as to the proper construction of that sentence. But my lord, that does not affect the certainty of the procedure as a matter of enforceability. It's got nothing to do with it, my lord.
Before the judge, you said that the parties was a reference to CAP and the trust.
Yes.
And does that remain your submission?
If I have to make any submission,
Well, I'm not answering the conditional
No.
part of your question, Mr. Hargreaves. It's simply a question of whether the submission you made before the judge is maintained before us.
it is, my lord.
It is a simple question because, as you know, I'm a simple man.
My lord, it is maintained for the simple reason that it would be very difficult to see how a decision arrived at by the trust and project co could, as a matter of law, be imposed upon Kajima. So, in other words, that sentence is merely stating, as it were, a piece of information. But, my lord, I don't need to make that submission for the reasons I've already given, which is that sentence does not affect the question of whether the procedure that we're discussing is or is not an enforceable procedure, being sufficiently certain. For now, may I come on to grounds 2 and 3? Can I take ground 2 first? Can I start by turning up IMS, which is in divider 12 of the authorities bundle? And would your lordships also please have open CPR part 11 in the white book, which I'm conscious I haven't yet been to. So I can take ground 2 quickly.
So it's page 525 of the white.
Correct, yes. Now,
And which tab?
it's tab 12.
Tab 12, yeah.
And it is a case in which my Lord Justice Popplewell was the judge in the commercial court. IMS was concerned with a situation where a party, first of all, made an application contending that the court had no jurisdiction at all due to ineffective service, and then quite separately and later on, after determination of that first question, made a second application seeking an order that the court decline to exercise its jurisdiction on grounds of forum non-convenience. My lords, what IMS was not concerned with was a situation either where there was a failure to comply with any condition precedent to the commencement of litigation, or where limitation had expired. Instead, under paragraph 28, your Lordship merely observed, I'm looking at the last 3 lines, your Lordship merely observed that where there's been valid service and where the challenge is as to the exercise of discretion on the grounds of forum non-conveniens, the appropriate relief is usually a stay of proceedings. And my Lords, that's not the present case, and in any event, what your Lordship have to say falls short of saying there is any sort of a default remedy. My Lords, in this respect, the judge made 2 errors. She determined that there was a default remedy when there was not. And if perhaps there is a default remedy in forum non-conveniens cases, she determined that it was engaged on the facts before her, which it was not. And, my Lords, the error can be seen in 2 places. Paragraph 82 of the judgment. The 82 is clear from the authorities to which I was referred that even in cases where claims are commenced in breach of mandatory jurisdiction, the default remedy under CPR 11.6 is a stay, with the remedy of setting aside a claim form being reserved for cases where proceedings have not been validly served, CINS. Now, so far as that's concerned, apart from the use of the language default remedy, one can see why the court has said it. But in 85, paragraph 85, her ladyship goes on and says, I agree with Mr. Webb that it would be difficult to extend snooks into cases involving a failure to comply with a mandatory ADR provision without cutting across the guidance given in the cases to which I have referred, which demonstrate that a stay is the appropriate or default remedy. Now, my Lords, that's where the judge respectfully falls into error. Whatever might be the case in relation to forum non-conveniens is not by any means the case on the facts before this court. And it is also apparent that it had an effect on her ladyship's decision making, because she found that it would be difficult to extend snooks, which is one manifestation of how it affected her decision making, because that would be to cut across the guidance given demonstrating that a stay is the default remedy. So the questions which the judge had to determine were simply these. Ought the court, in the circumstances, ought the court to declare it should not exercise its jurisdiction, and if it should not, what further provision, if any, should it make under Part 11, subparagraph 6, including setting aside the claim form, as we contend, or staying the proceedings, as my learned friend contends. Those are the questions for the court, and her ladyship had to address those questions untrammelled by any notion of a default remedy, and respectfully, she did not do so. No, sorry.
It's agreed, isn't it, that, I mean, the judge found that this wasn't a case under 11.1a.
That's right.
And that's not part of the appeal.
Correct.
So we're concerned with 11.1b.
Yes.
Fine, that was the first point. And the second point is this. Speaking entirely for myself, I understand completely your submission about the language that the judge uses in 82 and 85. I had myself read that as referring to using the expression default remedy as effectively the usual remedy.
Well,
because in every case but Snooks, that was the remedy that the court imposed?
Well, her ladyship may have intended that, but default remedy is not, respectfully, we would say, the language of it being merely the one that's happened to have taken place in earlier cases.
I understand that. If we deleted default and put in usual, you couldn't have a complaint?
No,
Or just on the stats, as it were? I mean,
That's
I get the
no.
point about snooks, of course, and that's a very important part of your submission. I understand that completely. But statistically, a stay has been the usual remedy.
But no, there's a reason for that, which is that there's no limitation issue.
That's why snooks is an important part of your submission. I understand that.
Yeah. So usual in circumstances where no party is in a position to say that limitation has expired, of course, I entirely accept that. But to say, in the end, I have to persuade your lordships on ground 3, which I'm going to move on to.
Yes.
But we do say that when considering ground 3, we perhaps can put it this way, that the judge did take a little step in the wrong direction by thinking that there was a usual way to approach these things in circumstances where the facts here were starkly and acutely different from that run of cases.
I mean, is ground 2 really part of ground 3?
It is really part of ground 3.
And if you don't get home on the ground 3 part of ground 3,
Yeah.
do you suggest you go home on ground 2 alone?
No. Now then, ground 3. A decision, if this court was to make it, to set aside the claim form, particulars of claim, is not in and of itself a draconian measure, as was suggested by the judge and by my friend. It takes on that appearance only by reason of CAP's own conduct. If it had got its house in order and referred the dispute to the liaison committee, none of these issues would have arisen. And importantly, there came a moment in time when CAP could no longer complete a referral to the liaison committee and issue proceedings in time. That point in time arose. The defendants, my clients, are not responsible for CAP finding itself in this position, and they even gave CAP the opportunity to remind itself of the position twice ahead of the moment in time when that moment arrived. Now, it's certainly true that the result of the order that we're asking for is that CAP's claim will be dismissed and then any further claim would be time-barred. But that is CAP's own fault. It's not because the remedy of setting aside the claim form is a draconian remedy. And we entirely agree that there is a discretion here to be exercised, but the exercise of that discretion, correctly understood, must be focused on the hard choice between the deprivation of a limitation defence in my client's hands on one hand and the deprivation of a claim on the other. Now, in our respectful submission, that has to be addressed head on and by reference to facts which are relevant to that determination, which are relevant to that exercise of discretion. We say respectfully that's what the judge entirely failed to do, because on her exercise of her discretion, she had to assume both that there was a condition precedent as she determined, and that it was enforceable, and that it had not been observed, not been complied with. And my lords, we say that the facts which are relevant to the exercise of that discretion, as properly understood, are the facts that we have detailed in our skeleton argument at paragraph 24. And those facts are these very important aspects of the situation. First of all, the parties were well aware that compliance with the condition precedent and a referral all taking place in time to issue proceedings before limitation is very tight. We make that point in paragraph 24A. It is precisely for that reason that the standstill agreement and its 4 variations expressly permitted either party, notwithstanding the standstill, to take steps to comply with the dispute resolution procedure and issue proceedings. Secondly, the respondent had ample opportunity to comply with its obligation to refer to the liaison committee, but chose not to do so. In our respectful submission, the learned judge failed to take that into account. It was a conscious disregard of its contractual obligation, which it stood to benefit from, and in our respectful submission, no proper explanation has been offered. Now, it's right that my learned friend says, oh well, we didn't know what the trust's case was. But as I showed your lordships in the correspondence, they did know what the trust case was, as long ago as 2019, and in any event, all they needed to do in terms of identifying the dispute in order to refer it, just as they did in the particulars of claim, was to say that their entitlement was an indemnity or a claim for damages in respect of whatever the trust claim turned out to be. So that's no excuse for the matter not having been referred to the dispute resolution procedure. My lords, the learned judge did not take...
Just so I understand that,
Yes.
who would have an indemnity?
The indemnity, the CAP are claiming an indemnity from my client in relation to the trust's claims against it for deductions.
Okay, so you say all they, when you say they, you mean CAP. All CAP
Yes.
had to do
CAP.
was to say, well, they were entitled to an indemnity from Kajima.
If and insofar as the trust is entitled to its deductions. None of that, I mean, in the end, they issued a claim form that described that, and in the end, they pleaded particulars of claim that described that claim. Now, nothing had changed to permit them to do that. That meant they couldn't have done that and referred the matter to the liaison committee.
That was on the 16th of December. That letter that identified the trust's position.
Yes, and it identified the position as being known about in 2019.
Was that 10 business days before the limitation period expired?
Well, no, maybe turn up the letter.
Yes. Tab 17, I think.
This letter is from Project Co itself, and in paragraph 5 it is recording that the trust position at the end of 2019 was this. So, my lord, by the time they wrote this letter, they had been aware for 2 years as to what the trust's position was, and in due course that is based on that, how they pleaded their claim in the particulars of claim, and of course there's no reason why they couldn't have done exactly the same thing in order to take the matter to the liaison committee. So, my lord, nothing turns on the date of the letter. The fact of the matter is that they knew what the trust claim was years earlier. And as I said to my Lord Justice Coulson, all they needed to do was say, well, the dispute is that we consider ourselves entitled to an indemnity of damages in relation to whatever the trust claim might be in relation to deductions.
I understand that. I was just trying to work out what on your case was the last available date for referring and being in time. Did the limitation period expire 3 days after the 29th of December? Is
Yes.
that the effect of the...
Yes. No doubt we can work this out over the...
There were quite a lot of non-business days at that
That's
time
right.
of year.
That's
That's why
right.
that's why I'm being
I did work it out at one point, but I haven't brought that with me. But we'll look at that.
Thank you.
Ah, humbug.
Yes, well. So, other matters which, in our respectful submission, the judge failed to take into account and give appropriate weight to. The fact that my client gave a month's notice was not called for. They made clear a month in advance that they weren't going to enter into any agreements. I have made that point. I know you all just have it. And then there was an express reminder that my client would reserve its position on the necessary pre-action steps on the 10th of December And I do recall working out that the 10th of December is in time for 10 business days before the expiry. And really, at the heart of it, the learned judge weighed the effect of making an order setting aside the claim form and so on the respondent, in the sense that it would be deprived of its claim. What in our respectful submission she didn't do, or didn't do adequately, was place in the balance that my client would lose its limitation defence. And that is a very hard question that the learned judge ought to have been focused on. But in our respectful submission, and it's a matter of impression when you read the judgment, she didn't. She instead made observations along the lines of it was a sensible thing to do, it was satisfactory, and it may not have worked if it had been done at the time. It's better to wait until proceedings are issued so as to save the limitation situation and then go into it. Now, in another set of circumstances, all of that might perfectly well be true, but respectfully, in circumstances where one's looking at the knowing failure to comply with a condition precedent and the deprivation of a limitation defence by the actions that did take place, there's a much more subtle balance to be arrived at. And for the reasons which I've explained, the fact that the parties knew about it, they put the problem in their standstill agreements, we gave a month's notice, 10th of December we said we're going to reserve our position. For all of those reasons, we say the discretion ought to be exercised in my client's favour, and that the matters that the judge took into account, respectfully, were not relevant to that focused and tricky decision.
I'm sorry, I'm interrupting a lot. In relation to the importance of not being deprived of a limitation defence,
Yes.
Do we get any assistance from the authorities on whether you should extend the validity of a claim form at the last minute so as to cut across a limitation period? I have in mind there's a decision of this court in a case called Cecil and Byatt, which I think says some quite trenchant things about how one shouldn't do that because of the importance of a limitation defence. And there may be others, but I wonder whether those are cases which we ought to have drawn to our attention.
Did your lordship say Cecil?
Cecil, C-E-C-I-L,
Yeah.
and Byatt, B-I-A-T-T.
Well, Lords, perhaps we can look at that and send a short note.
Thank you.
But lest it be thought that I'm not emphasising that point, I very much am, without needing to go to alternate authority. The limitation periods are generous. This contract provided for a 12-year limitation period. There is a public interest in the disposal of litigation when it becomes old and stale. In our respect,
On the fact that point doesn't, speaking for myself, have that much weight in this case, because the remedial works are still going on. So or arguably they just finished, or there's a reference in the documents to March 2022. It doesn't detract from your point about generous periods generally, because we're obviously a long way on from the completion of the original works, but we have to bear in mind that if the background to this was Grenfell, there were the works then done at coming to an end at about this period. What Lord Justice May says in Steamship Mutual does seem to be of less force.
well,
Particularly as we now know, under the Building Safety Act, my understanding is that in some instances the limitation period is now 30 years.
yes.
Quite what Lord Justice May might make of that, I don't know. But, one imagines he might have a trenchant view.
Well, that's right. But my Lord, I don't disagree with what you've said about the fact that remedial works were ongoing. And it is, of course, to Kajima's credit that it carried out those remedial works without dispute or fuss. However, I don't think that the point is any the less important, because limitation, both contractual and statutory, provides a clear and bright line that all the parties in any dispute are aware of, and which all the parties need to take great care to observe and curate carefully if they're not going to burn their fingers we respectfully submit has happened in this case. That remains as important as it has always been. And edging yourself towards the precipice with 3 days left to go before limitation expires is asking for trouble. The importance of limitation, finality and the public interest in that, my lord, remains undiminished by your lordship's observations. So, in essence, we've listed in paragraph 24 the points which we say are important in a proper and focused exercise of discretion. To that, we would just add 2 points, if I may. The point about Appellant's claim to teeter on the brink of limitation. Now, you know, its eyes were open to the risk of misadventure in doing that. And of course, finally, this point, that there's absolutely nothing wrong with, and everything to be said for, a party being held to the terms of its bargain. And that was the point made by Mr. Justice Silver in the Snooks case. And that is why he said, you're up against limitation. I'm terribly sorry, but I am going to set aside the claim. Why should you have an advantage? Why should you risk depriving the defendant of a limitation defence? You've put yourself in that position. It's nothing to do with the defendant that you're in that position. We say that is emphatically, my lords, the present case. It's nothing to do with us, and yet we might be deprived of a limitation. Well, my lords, if you're with us in relation to that, then we would invite the court to exercise the discretion afresh. We would say that the matters listed in paragraph 24, well, those are the matters that we rely on. And we have set out in our skeleton in paragraph 25 the matters which the judge relied upon and which we say are not relevant to the exercise of discretion. Well then, my lords, may I just introduce the situation with D2. That shouldn't take very long. May we start with the guarantee, which is in the supplemental bundle, provider 7. And behind divider 7, we're looking at clause 2.1, page 184. And there are really 2 passages which I rely on and how I will conduct my analysis. The first passage, paragraph 2.1, is that the primary guarantor, as primary obligor, guarantees the due and punctual performance by the contractor of each and all of its duties or obligations to Project K under or in connection with the building contract, past, present, and future, when and if such duties and obligations shall become due and performable according to the building contract. And if the contractor fails to pay any debt, damages, interest or cost, past, present or future due from the contractor to Project K under or in connection with the building contract, the primary guarantor shall as principal debtor pay such amount to Project K. So, my lords, that's the first part of the clause, and that is the operative obligation of the guarantor, if I can put it that way. There is then a proviso, and the proviso falls into 2 parts, as I shall describe it, provided always that the primary guarantor's liability under this deed in respect of any matter shall not exceed that of the contractor under the building contract in respect of that matter. And then there's a passage in brackets which we're not concerned with. And then, and, this is the second part of the proviso, and for the avoidance of doubt, the primary guarantor shall, brackets, for the purposes of ascertaining the extent of the contractor's liability under the building contract, and, I emphasise, accordingly, the extent of the primary guarantor's liability under this deed, be entitled to rely on the same defences, including any rights of set-off or limitations of liability, as those which the contractor is entitled to raise under the building contract, save for any as referred to in clause 4.3 below, which we're not concerned with. And so our position is that if these proceedings are set aside as against Kajima, then the guarantor will not be liable under this agreement either. And the analysis falls into three parts. First, by reference to the first part of the proviso, then by reference to the second part of the proviso, and finally by reference to CAP's own pleading of the claim. So the first part of the proviso, and I'm referring to the bit beginning provided always, up to the word and, is a proviso to the obligation as primary obligor. And so if the proviso applies, then no obligation is assumed in the first place, even as primary obligor. And that also explains why clause 2.4, which refers to the guarantee being a primary obligation, that's why that clause does not assist my learned friend. The fact that it's a primary obligation is also appears in clause 2.1, and we don't dispute that it's an obligation as primary obligor. But the point is that the proviso is a carve out from that obligation. And so the guarantee does not extend in the first place to providing for liability greater than the building contractor's liability. So if his liability is zero, so is the guarantor's.
Is the premise for that submission that if the claim against Kajima is time barred, the liability is extinguished?
Well, my lord, no. The way, there's several ways of putting the claim. In the present action, the liability is extinguished because the claim form is set aside. And if any new action were to be commenced, then the liability is extinguished because there is a time-barred offence. Now, I entirely recognise that there is or may be a distinction between barring of right and barring of remedy. But, my lord, for the purposes of this obligation, clause 2.1, we respectfully say that it's clear what the parties were driving at, which is that if the building contractor is not liable, nor is the guarantor. So the first part...
Isn't the distinction between barring the right and barring the remedy critical to that question?
Well, let me come on, my lord, to just the remainder of the submission, and then I can tackle that, because it may not, that distinction may not matter. Now, the other way of looking, the second part of the passage says this: and for the avoidance of doubt, the primary guarantor shall, and this important passage in brackets, for the purposes of ascertaining the extent of the contractor's liability under the building contract, and accordingly the extent of the primary guarantor's liability under this deed, be entitled to rely on the same defences as those which the contractor is entitled to raise under the building contract. Well, now, so far as that's concerned, if Kajima, it falls into two parts. In these proceedings, Kajima relies upon the defence that that when CAP commenced proceedings, it was not entitled to do so. In any subsequent proceedings, if this claim form is set aside, Kajima will rely on the defence that the claim against it is time barred. And my learned friend makes a distinction as well about whether that's a defence under the contract or some other form of defence in his skeleton. But it can be seen, even if that distinction matters, which we say it doesn't, that defending a claim by reference to clause 9.7 is a defence under the contract. Because clause 9.7 in the contract is what provides a defence. So, my lord, even if there may be some doubt about the distinction between extinction of liability or merely not being entitled to claim the remedy, that distinction doesn't matter for the purposes of the second part of the clause, which makes quite clear that a defence, whether under the contract or not, can be relied upon, and that's precisely what clause 9.7 confers in future proceedings and the clauses of the dispute resolution procedure in connection with these proceedings.
The same point may arise again, though, doesn't it? Because the second part of the proviso is all to do with ascertaining the extent of the contractor's liability under the building contract.
Well, my lord, well,
So Mr. Webb would say you're liable for 14 million or whatever the figure is. You may have a defensive limitation to that, but you're still liable, and therefore the calculation would still be done so as to ensure the guarantor is not liable for more, but is liable for that amount.
well,
I think that would be the point. I mean, it comes, but all I'm saying is I think that this question of the difference between the liability and the remedy, whatever, may matter to both parts of the proviso.
well, it may do, but my lord, respectfully, this clause in our submission is aimed at making sure that the guarantor is not on the hook in any different way or further or additional way than the building contractor is. And respectfully, we say if one looks at the clause as a whole, that there's the language which says that the guarantor's liability shall not exceed that of the contractor, and then there's the provision allowing for the reliance upon defences. We say that looking at this in broad terms and applying commercial common sense to it, we say that it's clear what that means, and that it means that if the liability of the building contractor is zero, because he has a limitation defence, well then so too is the liability of the guarantor zero. And I said I'd address this question in three parts, and the final part was by reference to the pleading, Cap's own pleading. The Lordships will find that in the core bundle divided 8. And I did go past it briefly, looked earlier. But we say that Cap's instincts in pleading the claim in this way are correct. Paragraph 64, page F93, that this is the claim guarantee. Insofar as Kajima is found liable to Cap, as set out above, Kajima Europe will also be liable pursuant to Cap, pursuant to the terms of the guarantee. And we say that formulated in that way, what Cap is here recognising is two things. First of all, that the liability of the guarantor is determined by reference to the liability of Kajima, and that if Kajima is not liable to Cap, then nor is the guarantor. So that's it so far as the second defendant, the guarantor, is concerned. And by Lords, that also completes my submission.
Could your last point be met simply by an amendment to delete the word found?
Well, my Lord, no, because on the analysis that we've on the analysis basis which we've addressed your Lordships in relation to clause 2.1.
Obviously, not if you're right on the first 2 points, but this third point.
All we're saying is that the pleader's instincts are right, and that's how clause 2.1 is to be construed.
Thank you.
It may not take us very much. So, my Lord, those are our submissions, unless I can help any further. We invite Lordships to allow the appeal to set aside the claim form, the particulars of claim, and to dismiss the proceedings.
Thank you very much. Thank you very much.
Thank you.
Mr. Webb, do you perhaps want to set out your stall?
I'm happy to say this much if it helps in 5 minutes. A brief structure maybe, and indicate where I'm planning to go. It may be by the time I've done that, there's not much time to actually go there.
No.
But I will be addressing matters under 5 headings. The first is to set out some key points from the factual background and also as far as the legal framework of this matter is concerned. Then I'll address grounds 1, 2 and 3 of the appeal in turn. And then my 5th and final point will be, like Mr. Hargreaves, to turn to the position of the guarantor, which is a cross appeal that is brought, but also Mr. Hargreaves flagged up in advance in his skeleton argument and somewhat straddles the position, I think, of a cross appeal in a fundamental central part of the appeal itself. I've probably got 5 minutes to start on the
Yes,
factual
please, if you
background
would.
and get going. And some of this, of course, you'll be familiar with from Mr. Hargreaves' initial introduction, but I hope I'm not labouring the point to go over some of the key matters that we say are central to the resolution of this appeal. And as you're aware, this obviously flows from a PFI contract dating back to 2004. You've seen the project agreement. It's a long-standing 25-year agreement to build and maintain a hospital. You've seen the building contract. Of course, that is a shorter-term agreement to build the hospital with the works carried out from 2004 to 2007. What you weren't taken to, I think you are aware of, but I will emphasise in any event, is that this claim specifically concerns primarily an attempt to pass on deductions within the framework of this contractual chain. What that means, and it's common to PFI contracts, is that under the terms of the project agreement, there are normally regular monthly payments made. If defects are found at the facility, in this case a hospital, normally in addition to the obligation to put right those defects, there is a complicated payment mechanism which we've not put in the bundle, whereby deductions fall to be made from those monthly payments by assessing how severe the defects are and to what extent the facility is impacted by those defects. They effectively take the role of compensation for loss of use rather than compensation for cost of cure, but they are liquidated and calculated pursuant to a complicated mechanism rather than unliquidated and at large. So it's that aspect which this claim is about, and there's an express provision in the construction contract, again I won't take you to it, whereby Kajima promises to indemnify the respondent for any deductions which are levied as a result of its breaches. As you are aware, the defects in this case were identified around 2018 and notified to Kajima in September of that year. As his Lord Justice Coulson noted, that's probably a post-Grenfell discovery in this case at the hospital. After that notification, Kajima did attend liaison committee meetings about these defects. It agreed to carry out the remedial works, as I know you have also been told. And as a result of that, the greater part of the claim that would normally be brought in these circumstances, which is the claim for the cost of cure, was resolved amicably. So there has been engagement. It is simply the matter of the deductions to be levied by the trust, which could not be resolved because the trust took the view that it could not assess the total deductions to be made until the works were complete, because it was only when the works were complete that the interference with its use of the hospital would cease, and it could give a total figure for the amount of deductions that had accrued over the course of the period the defects were discovered and then remedied. In other words, if you've still got people entering into wards using ladders, looking up in the ceiling, or taking the outside of the building off and making wards unusable, if that's still going on, the trust will say, well, we're still entitled to accrue our deductions. And until that's finished, we don't know what our bottom line figure is going to be. So whilst we had received indications as to what that level of deduction might be, and I'll take your lordships after lunch to documents showing that that was far from certain, whilst there had been indications, there was no certainty at this stage.
That's as to the total.
As to the total.
But do the deductions, does liability for the deductions, as between CAP and the trust, accrue month by month?
Liability as between CAP and the trust, in theory, accrues month by month, and strictly, the ordinary process would in fact be for that liability to accrue and the deductions to be made at source to the monthly payments. My understanding is that did not happen. Instead, the trust kept a running tally with the intention of negotiating over how much it would in fact deduct once the matter was behind everybody.
There was nothing to deduct from, presumably, because
No.
practical completion was a long time in the past.
The way these PFI contracts work is there is a funder in place who funds a lot of the work, and the payment for things is often somewhat back weighted. Turn around. Yeah, I'm getting nods. So the payment from the trust to the PFI vehicle is often weighted towards the end of the period. So in fact, not only are you being paid for your maintenance services over that 25 years, but you're in fact receiving catch-up payments to some extent for the construction work that was done earlier. And a funder is often the one who's involved in the overall contractual framework as well, and helps bridge that gap for a construction company who does want the money up front. Is that?
I follow. And so had the trust been making deductions month by month in this case, or were they waiting until to deduct a final figure?
My understanding is not. If I may just briefly turn my back. No, yes, they had not been levying deductions.
Thank you.
And my lords, perhaps one final point I could make before it may be time to break for lunch, which is just to understand the reason as to why the parties were in the position of being up against limitation, other than, of course, the late discovery of this defect. And that is found at paragraph 88.2 of the judge's judgment in the core bundle at page 59. And I just ask you to note there, it says Mr. Kersham's evidence is to the effect that CAP had initial discussions with the trust during the first standstill period, but that thereafter Kajima asked CAP not to progress negotiations because, although Kajima had commenced the remedial works, it still had a great deal to do and was not certain as to the total extent of the remedial works. Mr. Kersham says that this pause in negotiations was acceptable to the trust, and that it was agreed that negotiations between the trust and CAP should recommence when the remedial works had been completed. So it was at Kajima's request that these discussions were put back, and its request was that it be done to the end of the remedial works. And I flag up that although this is stated in the judgment as being a quote from Mr. Kersham's evidence, I would just flag up the last paragraph of the last sentence of the paragraph over the page. This evidence was not disputed by Mr. Tattersall. And so when it comes to assertions of playing with fire, so to speak, I do just flag up that that was to some extent at the request of the appellant, that matters be left to a later day, closer to the end of any standstill period or extended standstill period.
Good. Thank you, Mr. Webb. Is that a convenient point to break off? Thank you very much. Well, we'll resume then at 2 p.m. Thank you both.
All right.